The police didn't read me my rights. I'm attorney Allan Friedman, and that is one of the most common comments I get from my clients who have just been arrested by the police. My clients are really concerned because often the police have never read them their rights. What I'm going to do in this video is explain what these Miranda rights are and how they apply to your criminal case. A lot of people have seen TV shows where the police carry around a small card and they formally read the rights to suspects who have been arrested, and people think that police have to do this every time they make an arrest. That's not correct. What is Miranda? Miranda is a Supreme Court decision from back in 1966 that was made in response to really hardcore police interrogation techniques at the time, which were so draconian they were known by the nickname the third degree. Imagine giving someone the third degree and you're a policeman with a gun. The police may have softened up their approach a little bit today, but they still play by a really dirty set of rules. Back in 1966, people were often subjected to such intensive interrogation techniques by the police and coerced into making confessions to crimes that they never committed without being advised of their right to counsel. These overly zealous police often assumed that they had the right guy and just didn't care what they had to do to get a confession. So the Supreme Court found in Miranda there were too many times where police were forcing, tricking, or coercing confessions or statements out of suspects. So the Supreme Court required that before the police are going to interrogate someone who they have in their physical custody, they have to give them a series of warnings. These warnings are what's known as your Miranda rights, or being Mirandized when you're arrested before you're questioned. The court required that the police inform you have the right to remain silent. Anything that you say can and will be used against you at court. You have the right to have an attorney present during questioning, and if you cannot afford one, an attorney will be appointed to you by the court. That is basically what your Miranda rights are. Some key takeaways for Miranda and how it can affect you. Number one, you have to be in custody for Miranda to be functioning. Number two, you have to be being interrogated for the protections to apply. A lot of police interactions with my clients are not custodial arrests and are not interrogations, so Miranda really doesn't work. These important points about your Miranda rights. Number one, the police don't have to read your rights even if they arrest you, and if they're not going to interrogate you. So let's say they arrest you and then have you in the police station or in the back of a police car or in the cell and you yell something out. It can and will be used against you. Miranda does not protect you because it was not an interrogation. Two, you're not protected by Miranda when you're not in custody. That means that the police stop you for a traffic stop, or you come into the police station voluntarily, or if they're at your house for a domestic violence investigation, and you make a statement while you're not considered to be in custody, Miranda will not protect you. Three, if police fail to read you your Miranda rights, the remedy is for a lawyer like me to argue that any statements you made during an interrogation should be suppressed. Does not mean that the arrest itself is unconstitutional or should be suppressed. Just the statement would be suppressed. Even if your incriminating statements were suppressed by the court because the police failed to read you your rights, you could still be convicted at trial based upon other evidence. In fact, Miranda himself was convicted as trial for rape after the forced confession because they had enough evidence to convict him, and he served a jail sentence. In 90% of your encounters with Connecticut police, your Miranda rights will never even come up due to several reasons. In most cases, the police do not need your voluntary statement in order to secure enough evidence to arrest you. In other situations, the police will trick you with manipulating techniques into giving some kind of voluntary statement. One of the classic methods that a lot of my clients find out is they'll call you up on the phone if you're a suspect in a criminal investigation, and they'll say, "Would you like to give your side of the story? Would you like to come down and talk to us?" At this point, you're clearly not in custody, so if you do go down and say something or say something over the phone, it'll be used against you, and they don't have to read your rights first. Don't fall for the bait. No matter how tempting it may be to get your side of the story out, you're only going to dig yourself deeper into the hole. Call a criminal defense attorney first. Other times, they will tell you that things will go easy for you if you speak to them, so many of my clients have signed waiver of rights forms which clearly set forth all the Miranda warnings and proceed to give voluntary statements against them. Because the police use mental manipulation and coercion to trick them into signing these forms. Do yourself a favor and never speak to the police without first speaking to an experienced criminal defense lawyer first. If you follow my advice, you'll never need a Miranda warning because you will never ever speak to the police without first contacting a lawyer. Clients who give statements to the police are always shooting themselves in the foot. Why help the police to build a case against you? Let the police build their own case. Thanks for watching today's video. If you'd like to speak to me about any legal matter, feel free to give me a call for a free consultation. And if you're interested in this kind of content, click the subscribe button below so you'll be notified when we post new videos. Thanks so much for watching.